Welcome to Michigan Condo Voices, where real co-owners and real Michigan communities come together. We break down the issues that matter most with clarity and transparency. Let's get into today's episode.
Hi, everyone. This is Stephanie with Michigan Condo Voices. There are moments in some communities when a decision is made by a condo board, and at the time, it may seem like a reasonable course of action, a change in direction, a different approach, or a new way of managing the community. But sometimes those decisions don't happen in isolation. They happen within existing agreements. And that's where this Michigan case becomes important. Vista Property Group LLC versus Schulte. In this situation, a condominium association entered into a contract with a new property management company to begin managing the community. Like many associations, the goal was straightforward to support day to day operations such as maintenance, administration, and overall coordination. But shortly after that agreement was put in place, the composition of the board changed. A new board took office, and with that change came a different decision. The new board chose to cancel the contract with the new management company and continue working with the previous firm instead. On the surface, it may have seemed like a practical choice, but the contract with the new company had already been executed, and that decision led to a legal dispute. The management company whose contract had been canceled filed a lawsuit arguing that the association had breached its contract. When the case reached the Michigan Court of Appeals, the court concluded that the association's actions did constitute a breach of contract. The case was then remanded for a determination of damages. Ultimately, the Michigan Court of Appeals reversed the lower court's decision holding that the association breached its contract with Vista, and Vista was awarded $44,787.71 in damages, plus costs after finding the association prematurely terminated a 3-year management contract. And that's where the broader lesson begins to take shape. Because in condominium governance, boards do have authority to make decisions on behalf of the association, but that authority exists within certain boundaries. Existing contracts, governing documents, and applicable law. When an association enters into a binding agreement, the obligation doesn't simply disappear when the board leadership changes. And decisions made after the fact can still carry financial consequences. From a co-owner perspective, this really matters because the association represents all co-owners collectively, which means that financial outcomes tied to board decisions, including contractual obligations, can ultimately affect the community as a whole. And over time, cases like this highlight something very important. The governance isn't just about making decisions. It's about understanding the commitments that already exist and how those commitments continue to apply. As with all cases, outcomes depend on the specific facts and governing documents involved. But this case serves as a reminder that while boards have authority, how that authority is exercised, especially in relation to contracts, matters just as much. Take what you need and leave the rest. You're always welcome here. Take care, everyone. Thanks for joining me.